Hello, welcome to today's video in which we will be looking at OCR A-Level Law. This is the new curriculum that started in, I think, 2020. We will be focusing on how to write, structure and improve answers for question 2, the 12 marker, which will be on all 3 papers. So, question 2 is the 12 marker. OCR recommends you spend 18 minutes on it. This gives you 1.5 minutes per mark. Question 2 is a discuss question. So, for example, we have this question here. Discuss the advantages and disadvantages of the literal rule. This question requires an evaluation of the literal rule via the use of advantages and disadvantages. The answer should be as broad or as narrow as the question. AO3. For question 4, we need to know and use AO3, in which we need to analyze and evaluate legal rules, principles, concepts, and issues. So that means we should be able to critique the rules, the strengths, limitations, advantages, disadvantages of this area of law or legal process. To achieve good marks, you need to be able to develop points into extended evaluative points or well-developed points. So the paragraph structure should be like this. You should have a point which will be worth 1 mark. So you need to further develop the point, which will get you 2 marks. And then if you further develop the developed point, you'll get a well-developed point or an extended point, which is worth 3 marks. Now, for question 2, you need at least 4 well-developed points to get the total 12 marks. To get a point, you just need to explain in this case, you just need to explain the advantage and the disadvantages of the literal rule. To get a developed point, you can either use a case, but if you can't include a case, you can further develop and explain what is the advantage. So further develop and explain the point. And then to get a well-developed point, you need to link your advantage to a broader theme like justice or democracy. This will enable you to reach the level 4 band. And that brings us on to the levels. There are 4 levels. So an answer which is level 4 will be worth 10 to 12 marks. An answer which is level 3 will be worth 79 marks. And a level 2 answer will be worth 46 marks. So if we look at a level 2 answer, we should be able to get the AO3, which is a basic analysis and evaluation of legal concepts and issues. The response should partially focus on the question, and some of the key points should be discussed. But then to improve to a level 3, you need a good analysis and evaluation of a range of legal concepts. The response should mainly focus on the question, and you should discuss and develop most key points. To get a level 4, you need an excellent AO3, which means excellent analysis and evaluation of a wide range of legal concepts and issues. Your answer needs to be focused on the question, needs to be completely focused on the question, which means no waffling whatsoever. Your answer needs to be concise, precise, and to the point. And your points need to be fully discussed and developed. An examiner would basically use these levels as a framework to place your answer in. If you have at least 2 well-developed points, your answer would probably be a level 4. If you have less than that, then it'd be a level 3 or level 2. And that would be based, and the examiner would base it on your paragraph structure, how many well-developed points, developed points, and points you have. And he will base it on AO3, to the extent you have evaluated the legal rules and principles, concepts and issues. So now we're going to be analyzing this answer, which is a level 4 exemplar answer. Discuss the advantages of using arbitration as a way of dealing with a civil dispute. One of the main advantages of arbitration is its flexibility. This is the opposite to civil courts, where there are strict procedures and timetables. So he goes straight to the point. One of the main advantages of arbitration is its flexibility. That's his point. This is the opposite to civil courts, where there are strict procedures and timetables. Arbitration is good as parties are free to choose a formal or informal hearing, or even if they have a hearing at all. Parties are free to choose a formal or informal hearing, that's his point, or have a hearing at all. Another point, part of his point. Unlike court, parties can choose a paper hearing. Another point, paper hearing. The paper hearing is an advantage as the parties can carry on with work and life and simply await the decision of the arbiter in the post. This is him developing his point, explaining why it's an advantage. It's an advantage as parties can carry on with their work and life, simply await the decision of the arbiter in the post. If there's a formal hearing, the parties can select a time and place convenient to them both. And he's further developing his other second point, formal hearing. The parties can select a time and place convenient to them both. This is an advantage as the hearings are not dictated by set opening hours or strict court procedures. However, if witnesses and lawyers are involved, this can make the procedure expensive. So now we can look at some keywords he's used. So here he goes straight to the point. One of the main advantages of arbitration is its flexibility. We use opposite to compare it to civil courts. He then uses arbitration is good to list more points. Once again, he uses unlike court, to compare it to civil courts. The paper hearing is an advantage as he's linking it back to the question, explaining why it is an advantage. And then here again, he's explaining why formal hearings is an advantage, once again linking it back to the question. And then he uses however to introduce a disadvantage to show that he recognizes there are disadvantages in arbitration as well as advantages. So he's discussing the extent of advantages, and this gets him into that level 4 band. I'd say this question is worth 3 marks. Another advantage of arbitration is that it is carried out in private and away from the public eye. So once again, he's gone straight to the point. It is carried out in private, away from the public eye. That's his point. And now in the next sentence, he explains his point. Businesses would much rather nobody knew if someone had taken legal action against them and what they were ordered to pay in compensation. That's his developed point. However, now he's further developing his point. However, some say this is a disadvantage as businesses should not be allowed to hide their faults behind arbitration. So if we want to check some key points, another advantage of arbitration, so going straight to the point, another advantage of arbitration. He's linking it straight to the question. Talking about an advantage, this is what examiners are looking for. They're looking for advantages. They aren't looking for anything else. They just want a straight and forward, clear answer to the question. The question's asking for advantages, and they're looking for the advantages in your answer. So just give it to them plain and clear. However, this is another key word. He uses it to introduce a disadvantage. I'd say this question is worth 2 marks because I'm being a bit strict here, but I say it's worth 2 marks because he could have added in a bit more. He could have explained why this is an advantage for businesses. So he could have written something like, as it could be damaging to their reputation, and so on. And that would further his developed point, explaining why it's an advantage, which is once again linking it back to the question. So, on to the third paragraph. Unlike court, arbitration allows the parties to pick their own arbiter. This is an advantage, as the parties can pick someone who has specialist technical knowledge of the issue at the center of the dispute. So, he further develops his point. For example, in a dispute involving a construction company, the chosen arbiter might have previously worked in that field. So he uses an example to also further develop his point. In the civil courts, the judge will be a legal expert, which is good if a point of law arises, but not so good if a technical point comes to light. This is him extending his developed point, making it a well-developed point. By having a technical expert, it often eliminates the need for expert witnesses, saving time and costs, another advantage. So first, he compares arbitration to civil courts, which is him just showing off his knowledge once again. Another advantage, which is a keyword. This is an advantage, another keyword, going straight to the point. And then, for example, this allows him to introduce an example which would further develop his point. And this is a very good way of further developing your point. I'd say this one is definitely worth 3 marks. Arbitration hearings tend to be quicker than court hearings, and as a result, they're also cheaper. So they tend to be quicker than court hearings, and as a result are cheaper. That's his point. Courts often have a backlog of cases, and there is a lot of waiting time. This is not usually the case in arbitration. This is him developing his point. Not usually the case in arbitration. Anything that makes a case quicker will make it cheaper for both parties. And then he talks about a disadvantage. However, arbitration is becoming more and more popular, and as a result, there can be a wait for the chosen arbiter to be available, as they are quite busy. And that is further development to his point, an extended point, if you will. And that makes his question worth 3 marks. So now if we take a look at some of the key words he's used, straight to the point, and then obviously his however, which is used to bring in a disadvantage, which gets him into the level 4 band. So this answer demonstrates a sustained focus on the question from start to finish. It shows a wide range of issues which are evaluated to show the advantages of arbitration. There's a clear chain of discussion linking one issue to another. The answer also recognizes there are some negative aspects of arbitration, and those negative aspects assist in fully developing the discussion points, which is exactly what you need to get into that level 4 band. So overall, it's an excellent evaluation of the advantages of using arbitration as a way of dealing with a civil dispute. So if we tot up the total marks, it is 11 out of 12, and that would be a perfect level 4 answer. So what I suggest is you go ahead and try do this question yourself, and you analyze and try and mark your answer similar to the way I have done. I find it best to structure the answer like this, with 4 paragraphs, each of which needs to be a well-developed point, which would get you 3 marks each. And that would obviously get you your 12 marks. So go ahead and try it yourselves and mark it and see what you get. And the more practice you do, obviously, the better you'll get. So see you in the next video.